Under this new interpretation of the law, the suffragette movement, which fought to gain women the vote in Britain over a century ago, and whose members are uniformly extolled as role models by the very politicians who support Palestine Action's proscription, would undoubtedly have been declared a terrorist organisation. It is sometimes forgotten, often willfully, that the suffragettes operated underground cells that organised hundreds of bombings and arson attacks in pursuit of their goals, killing 4 people and wounding at least 24. The 6 defendants in the so-called Filton trial, named after the suburb of Bristol where Elbit's drone factory, which they broke into on August the 6th, 2024, is located, were accused of 3 charges: aggravated burglary, violent disorder, and criminal damage. Crucially, one of them, Samuel Corner, was also accused of grievous bodily harm with intent. After police arrived at the scene to arrest the activists, Corner struck one of them in the back with a sledgehammer the activists had been using to smash up Elbit's drone production line, causing a small fracture in the policewoman's vertebrae. When the media did cover the case, which was rare, it was to focus almost exclusively on the injury to the policewoman, framed in such a way as to suggest that her back had been shattered. In fact, the fracture was so small it was not evident in an X-ray and missed on a first MRI scan. The recommended treatment was 6 weeks of mild rest and over-the-counter painkillers. The police were also allowed to release a highly selective video of edited scenes of confrontation between the activists, Elbit security guards and the police. Another abuse of legal process in the case designed to whip up the public mood against the Filton Six. During the trial, Johnson oversaw an extraordinary number of legal manipulations that helped the government. The defendants were denied the right to refer to their motives in attacking the Elbit factory. The terms genocide and ethnic cleansing were barred from the proceedings. The type and use of the weapons damaged in the attack was concealed from the jury. The defense was given no opportunity to cross-examine Elbit staff. Video evidence was introduced by the police that had been in the sole custody of Elbit for a year after the attack. But most egregiously of all, Johnson ruled that the jury must not be informed of its right to acquit on the basis of conscience. Under a principle known as jury equity, established in British law hundreds of years ago, juries are allowed to defy a direction from a judge that a defendant has no legal defence. In fact, Johnson actively encouraged the jury to think that they had no such right. The legal defence barrister, Rajiv Menon KC, used his closing speech to defy the judge and alert the jury to this right. Johnson responded in another legal first by instituting contempt of court proceedings against Menon, which would ultimately be overruled by the Court of Appeal on procedural grounds amid mounting disquiet from the legal profession.